James Madison said that every word of the Constitution decides a question between power and liberty. So the content, the words, are very, very important. So it's our hope and our intent during this lecture that you're going to understand the ratification debates and the ratification process and the purposes that were set forth in the preamble of the Constitution and, in fact, the content of Article 1 itself. So with Article 1 of the Constitution, Lecture 5, here's Jake McCauley.
Ratification debates. The term federalism simply means shared power between federal and state governments. The constitutional supporters called themselves the Federalists. These were men like Mr. Madison, Hamilton, John Jay, and they had two advantages when debating this Constitution. Number one, federalism was a popular term, so folks already knew what it meant and they were familiar with it and they liked it. The second is that they were intimately involved in the process of developing the Constitution. The Anti-Federalists had not been a part of it. They had not even seen that document until September 17th. The Anti-Federalist arguments, which were championed by men like Patrick Henry and George Mason, were that Congress had authorized the Convention to only revise the Articles of Confederation, not to write a whole new Constitution. There was defects in the Confederation, and nobody would deny that, but they could be corrected by just a few amendments. There was a lack of Bill of Rights, and this was dangerous to them. A republic could only succeed in a small nation. Large nations need to be loosely confederated, and this was taken from the thoughts of Montesquieu. The federal government had far too much power under this new document, and Congress controlled both the Treasury and the military. So a man who holds in one hand the purse and the sword will ultimately lead to despotism. The judicial review, also in the new Supreme Court, could be dangerous. Now, the Constitution was ratified, and 9 states were required for this ratification. Delaware started the ratification on December 6, 1787, and that led all the way up to the 9th state, which was New Hampshire. And this happened in 1788. And finally, all 13 colonies jumped on board, 13 new states, when Rhode Island finally ratified in May of 1790. So now we need to discuss the document itself. The preamble to the Constitution starts with "we the people." That means of the states or individuals. This shows that the government power is derived from the consent of the governed, we. It shows the framers' view of the covenantal or the contractual relationship and nature of government authority. In order to sets forth the basic purpose for which the government is formed, and these are only basic principles. To form a more perfect union, this was to end the disunity that was running rampant under the Articles of Confederation. To establish justice. This was to provide an orderly court system. And this also recognizes that there is such thing as justice, which implies a fixed absolute standard. To ensure domestic tranquility. This was to prevent insurrections, such as were threatening under the Articles. Provide for the common defense. The framers believed in defense and had difficulty providing for the common defense under the system of voluntary requisitions. The purse was always low. To promote the general welfare. And notice the term general. This does not imply specific welfare where we're helping specific groups of people. And to secure the blessings of liberty to ourselves and our posterity. This shows the founders' fundamental concern for liberty. Also shows they intended the Constitution to be a permanent document, one that would last through the ages. It shows their concern for future generations when speaking of posterity. This may also imply the protection of unborn children, knowing that they had not yet been born but would be born. This was for them as well. Do ordain and establish the Constitution of the United States of America. Again, this demonstrates the covenantal or contractual nature of government authority. Now, the preamble simply states the purpose. It grants no powers to the federal government. It seems to be the why again, but it's a lot more brief because the Declaration of Independence was the original preamble to the Constitution. It preceded it. It gave why we created this Constitution. Moving on to Article 1 of the Constitution, the very first sentence says, "All legislative power herein granted shall be vested in a Congress of the United States." So you see the term all, and all means all. That's all means. It is vested in the Congress. It cannot be divested or taken up. It can't be assumed by another branch of government. Legislative authority is established in a bicameral legislature. Two houses are in this Congress. The House of Representatives was the popularly elected house, and it represented the people by their district. Secondly, you have a Senate. Prior to the 17th Amendment, senators were chosen by state legislatures, which is more closely associated and answerable to we the people. This change represented a change away from a constitutional republic, and this moved more towards a democracy. Why was there two houses? Well, this was a result of the Great Compromise suggested by Roger Sherman of Connecticut. Before 1915, the Senate was an important means by which the state could influence and check federal power. So the states, for example, could recall their senator and send another one in his place. That was through the authority of the governing body of each state. This was partially also parallel to the English Parliament. The House, like the British House of Commons, was more popularly elected, whereas the Senate, like the House of Lords, was more aristocratic and deliberative. Requiring two houses to pass a bill before it becomes law cools hot-headed legislation, and it provides additional time for reflection. It's very difficult to get any two men to agree on much in this world, but imagine when you have two different houses deliberating. The purpose of this, again, is we don't want government to do a whole lot. So if they are going to do something, they all better agree on it, and that would mean that it's very important for it to get done. Can a bicameral legislature thwart the will of the people? Well, the answer is yes, and our founders had it so. They designed it specifically because they distrusted popular majorities. They created a constitutional republic, not a democracy. The majority will did not prevail, law did, and that's why we have the system that we have. The distinctions of a republic are that a republican government is indirect through representatives. A democracy is more direct. In a republic, the law is supreme, and all men, including its leaders, are subject to that law. The law is king. This is an objective, fixed standard known as the rule of law. In a republic, the minority has rights which even the majority cannot take away. In a democracy, the majority rule is absolute. This is a subjective, ever-changing standard that is known as the rule of man. Sections 2 through 6 deals and provides for the composition of the House and Senate, and establishes the authority of each House to determine its own procedures, its disciplines, etc. Section 7 deals with the legislative process, that all revenue bills originate in the House. That means the people. If we're going to tax the people and take their money, then they are to be the ones that should be originating these bills. The Senate, though, must concur with the bills. Legislation starts in the Congress. The President only suggests legislation. He cannot introduce it. He must find somebody else to do that is in Congress. There is a presidential veto that's dealt with. The President may veto the bill, implies the whole bill. He cannot line item it, take things out he doesn't like and leave the rest. And Congress may override his veto with 2/3 of a vote in each House. This also deals with Sundays are accepted on signing in bills. As we move on to Section 8, I want everybody to pay close attention, because here is where you can find what government has the authority to tax and spend for. In other words, if they're doing something that is not listed here, it is unconstitutional, therefore unlawful, therefore criminal. Section 8 says that Congress can tax and spend for the payment of debts, for the common defense, for the general welfare. With respect to general welfare, Thomas Jefferson asserted Congress has not unlimited powers to provide for general welfare, but it is restrained to those specifically enumerated. With this in mind, there were two Supreme Court cases that acted as watershed moments when we moved from a biblical view of general welfare to a pagan view of general welfare. This was in 1936, and this was the definition of general welfare. General welfare implies government may not tax and spend for specific welfare of individuals, regions, or socioeconomic groups. But in the very next year, this is also during the New Deal that FDR was bringing across. This was his Supreme Court at that time, or this was the Supreme Court of his administration. In 1937, Stewart Machine Company versus Davis, the courts ruled that Congress may tax some groups and subsidize others. This is diametrically opposed to the decision the year preceding. Thus, they will stimulate the general welfare. So now the distinction between general and specific has been virtually obliterated. It's gone. There is no difference between the two terms. That word generally has been effectively written out of the Constitution and vastly expanded federal power. So to give you an analogy of how that word was changed, it would be no different than if I lobbied Congress and said to them, listen, I want to stimulate the economy. Give me money so I can buy 5 houses, 10 boats, and 6 cars. Do you see how it will help the general welfare because I'll stimulate those particular industries? That's as silly as this is, and this rationale. Moving on, Congress may also borrow money, regulate commerce with foreign nations and with Indian tribes and among the several states. This is not within the state itself. States were sovereign. This was between the states, interstate commerce. But as we look at another watershed moment, we can see where even that wording has changed. Federal government is aggrandized power again. With respect to this Commerce Clause, the difference between interstate, inside of the state, and intrastate, outside of the state or between the states, we have the court's ruling in 1936, Carter versus Carter Coal Company, that Congress cannot regulate intrastate production under the guise of regulating interstate commerce. The very next year, 1937, again, the courts come back and rule that Congress can regulate labor disputes in intrastate steel production when necessary to ensure free flow of steel in intrastate production of any goods which are intended for interstate commerce. Perhaps the most bizarre example of this is the case of Wickard v. Filburn. The courts ruled that Congress may regulate domestic production of grain intended for consumption by livestock on the same farm, because such production could potentially affect interstate commerce. Now in this case, Filburn grew more grain than the federal agriculture quota allowed him, but he kept the grain on his farm and fed it to his pigs. The grain never even left his farm. So he claimed it had nothing to do with interstate commerce or the federal quota that he had allegedly broke. The Fed countered by saying, you were supposed to produce less grain for the elevator and feed your pigs the rest of the quota you were allowed to grow. Or you should have bought grain directly from the elevator to feed your animals if you wanted to turn in your full amount of the quota. So again, the rationale is, by not participating in interstate commerce, the federal government has determined you are participating in interstate commerce. You can clearly see that both of these decisions have effectively obliterated the distinction between interstate and intrastate commerce and vastly expanded federal power. Congress may also make rules for naturalization, not immigration, and bankruptcy. They may coin money, regulate money value, fix weights and measures, punish counterfeiting, establish post offices and post roads, establish rules for copyrights and patents, establish federal courts that are below the Supreme Court. They may define and punish piracy and felonies on high seas, and violations of the law of nations. Congress may declare war, grant letters of marque and reprisal. This is authority given to ship captains to seize foreign ships. They may make rules concerning captures on land and water. Raise and support armies. Now the term here, armies, is a generic term for non-naval forces. This was broad enough to probably include the Air Force. There's a 2-year limitation on funding, which indicates armies were to be temporary, not permanent. because the basis of land defense at that time was the militias under the state control. They were able to provide and maintain a navy. This is a more permanent force. You can't quickly train for this, therefore it needs to be more permanent. They also make rules of discipline for the military forces. This is where we have the Uniform Code of Military Justice. They may provide for calling militia into federal service to execute federal laws, suppress insurrections, and repel invasions. Congress may also organize, arm, and discipline the militia. Congress does control the militia while in federal service. However, the states reserve the right to appoint militia officers subject to the discipline of Congress. They may also control the District of Columbia and other federal property. This includes forts, magazines, arsenals, dockyards, and other needful buildings. Interesting to note is what it does not include, and that is national parks, national swamps. In reality, the federal government now claims to own massive amounts of land, but there is no constitutional authority for this ownership. Congress may do what may be necessary and proper to carry out foregoing powers and other powers granted to Congress, and this is often called the Elastic Clause because it purports to expand federal power. But really, federal power in this clause is limited to that which is necessary and proper to carry out other foregoing or delegated powers. Those foregoing powers is a list of 17 of them. So if Congress could do whatever it thought to be necessary and proper to tax and spend your resources, then why list these 17 things? In McCulloch versus Maryland in 1819, necessary, according to the courts, means reasonably suited now and not absolutely indispensable. So they broadened the term. An example, is this pulpit necessary for me to teach this course? Well, no, it's not necessary, but according to the new definition, it means reasonably suited. Well, then it is, I guess. Proper means not forbidden by other provisions of the Constitution. Now, this is a reverse of the power flow. Congress is not able to do whatever is not written. It's only able to do what is written. Section 9 are the limitations on congressional authority. The Congress cannot forbid the slave trade before 1808, cannot suspend habeas corpus except in an emergency. This is a writ demanding that the government either give legitimate reason for holding a person or they have to release them. They cannot pass a bill of attainder. This is a legislative finding of guilt. That is left to the courts, and you cannot pass ex post facto laws. This means after the fact, a law punishing a person for an act that was legal when he committed it, nor can they raise the status of the offense after the fact or increase the penalty for the offense after the fact. Or could they create a law making it easier to convict after the fact? Direct taxes must be in proportion to the census. No tax or duty on items exported from one state to another. For example, when you shop from a catalog or the internet, you're not taxed. No preference for local ships or ports over others. No money drawn from the Treasury except by appropriation of Congress with regular public accounting. No titles of nobility are allowed as well. And this was a concept of equality. The final section, Section 10, deals with the limitations of state authority. The states may not, and we see this also embodied in Article 10 of the Bill of Rights. It says the powers not delegated to the United States by the Constitution nor prohibited by it, being the Constitution, to the states, are reserved to the states respectively or to the people. States may not enter treaties or alliances or confederations. They may not grant letters of marque and reprisal. They may not issue money or make anything but gold and silver coin a tender in payment of debts. It's kind of funny. I'm not sure the last time that you've paid your state income tax with gold or not. States may not pass bills of attainder. They may not pass ex post facto laws, nor pass law impairing obligations of contracts. Now, the framers believed the right to make and enforce contracts was a God-given right. This wasn't a government concept. But in 1934, around the same time period of things we've discussed earlier in this lecture, the Home Building and Loan Association versus Blaisdell, there was a state moratorium on mortgage foreclosures. The courts found that that was reasonable under emergency circumstances. So, the law is the law, except when it's not the law. Well, that makes no sense at all. The courts have effectively written unreasonably into this clause where framers did not do so. The state authority to interfere with private business relations has thus been vastly increased. It started with that crack. States may not grant titles of nobility. States may not, without the consent of Congress, tax imports and exports, except as necessary for inspections. The states may not, without consent of Congress, levy duty of tonnage on ships, keep troops or ships in peacetime, or make agreements or compacts with other states, or make war, except when invaded or in imminent danger. So now we've covered Article 1. Remember, all legislative authority is vested in Congress, and it established certain enumerated limited powers to tax and spend, and the things Congress can do and the things the state can't do. Thank you so much for joining us.